You bring a lawsuit against your careless doctor, or maybe you bring a lawsuit against a careless driver. And now, as part of your claim, you say that you suffered lost earnings because of this carelessness. But there's a problem. You refuse to release your tax returns, like somebody else we know. What happens next? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so you brought a lawsuit against your doctor claiming that he was careless and caused you significant harm and injury. Or maybe you were involved in an accident and now you're out of work for a period of time. As part of your lawsuit going forward, you are claiming that you are unable to work. You are claiming that from the time you suffered your injury up until the time this case finishes, you will be unable to work. And now you go ahead and document all of the lost earnings that you've had. The defense gets the paperwork that says you're bringing a claim for lost earnings in addition to pain and suffering. And now they say, okay, fine, prove it. Prove what your lost earnings were. Prove what you were earning before you suffered your injury. Prove what you would have earned into the future. Show us proof. So now I contact you and say, listen, I need your W-2 forms. I need your income tax records for 3 years before this incident happened. And you turn around and say, wait a second. If the President of the United States doesn't have to release his tax returns, then there's no way I'm going to be releasing my tax returns to you or to the defense. Wow. Wow is all I have to say. Well, guess what? If you do not provide your tax records, you know what's going to happen? Then there is no way to prove your lost earnings claim. If we cannot document and support your claim that because of your injuries you lost X amount of dollars each and every year, and you will lose X amount of dollars into the future, for the foreseeable future, for the remainder of your work life expectancy, then guess what? Then there's no way to prove that claim at trial. None. The judge is not going to allow us to put in proof unless we have documented evidence, and the defense would be well within their right to stand up and say, Judge, we have no proof other than Mr. Oginski's client verbally saying this is what they were earning. This person might be true in what they're saying, but we need to document it and to prove it for ourselves. And the only way we can do that is with these tax returns, with the W-2 forms, with the 1040 forms. We need that. And you know what? If you intend on bringing a claim for lost earnings, you absolutely have to provide that information. We have to provide pay stubs and employment records to the defense. We have to provide them with permission slips, authorizations that will allow the defense attorneys to go ahead and get your employment records directly from your employer. Now, you should know there's a technicality here. If you work for yourself, guess what? You are required to produce your actual 1040 tax returns. If, however, you work for a company and are an employee, then we only have to provide your W-2 forms. So, to go back to the title of this video, if you refuse to produce your tax returns and your tax documents to support your claim for lost earnings, guess what? There is no possible way we can go forward with that part of the damages claim in your lawsuit. The judge will not allow it at all. On the other hand, if you do want to include that and you can justify to show that you lost X amount of dollars each and every year that you were unable to return to work and you will lose X amount of dollars into the future, then fine, now you've got to support it with documentation. So why do I share this with you? I share this with you because sometimes people come to me and say, listen, I am not turning over my tax records to you or to the defense. And now you know what I say. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.